Okay, guys, sorry about that. I was pulling up some documents to read here. I've been a little behind on these cases with Blake Lively and Jed Wallace and the Jones versus Abel case. And I need to catch back up on that, and I'll start doing a little bit better. But I needed a break from this whole Blake Lively universe for a while. So I had to take some time back, and now I'm going to start keeping up again. So these came out, I think, at the end of the week, either yesterday or at the end of the week last week. And I also have some stuff here in Wallace that I'll go over from last week as well. This won't be a super long stream. I'm just going to catch up on some of the important parts or the more interesting parts. I will also be on with Omar at midnight Eastern, 9 p.m. Pacific, to talk about the Clancy case. But I wanted to do this separately and first. So I haven't seen, I'm sure, some of you in a while because a lot of people just follow me for this case. So if you are back after a while, welcome back. I apologize for not keeping up, but I really did need a break from all that. So I need a break from the internet in general, but you know, how is that possible these days? You work on the internet, it's crazy. So, all right, I'm going to start out by reading some new pages of Blake Lively's deposition. I want to thank our friends at docketupdates.com and the It Ends With Lawsuits subreddit for putting these things out there for me to find easily. Also, I go to courtlistener.com if you guys know where to find free documents there. There is a letter that just got filed, but I don't see it popping up on Court Listener yet, so I'll keep refreshing, and if it's anything interesting, we'll go over it. Okay. Right. We'll start with Blake's deposition pages, and we'll go from there. Hold on. Oh, God. Hold on. All right. Sorry about that. There's a text I had to read. Let me pull this up now. There we go. And just so I can turn the screen brightness down, I might hide my face while I'm reading this stuff. I'm downstairs on my laptop. I'm not at my desk. As usually, you guys can usually see that because the background is different. But it's just hard to read with the screen so bright. And if I turn it down, it's like my face looks creepy and dark. So, all right. Can you guys read that? I want to zoom in a little bit more. There we go. You should be able to read it now, so I'll go through it with you. There's not too much of Blake Lively's, but we'll do hers first, like I said. It says, once again, I'm not Melissa Nathan, so I can't speak to all that she did. And, of course, these deposition pages, we will never get to see Blake's full deposition like we did with Justin and Jamie's. But, so it starts kind of here where it says negative stories about you, but we don't know what came before that, unfortunately. So it says, once again, I'm not Melissa Nathan. I can't speak to all that she said. The lawyer asks, do you know anything that she did to contribute to negative stories coming out about you? Blake says, I have an understanding, yes. And where is your understanding from? And then her attorney, Ezra Hudson, says, well, objection to the extent it calls for attorney-client privilege communications, in which case I instruct you not to answer. And I think that's funny because she has that understanding from communications that she got outside of these lawsuits, right? Van Zandt was the company she used to obtain this information, and it had nothing to do with her lawsuits against Van Zandt had nothing to do with her lawsuits against Justin Baldoni or anyone else, because Van Zandt never had a contract or agreement with these people. So, but we know that now, of course. Blake says, well, there are elements that don't involve privileged communications, documents. Which documents? She says text messages, emails. The lawyer asks, you're talking about, I'm assuming this is Friedman grilling Blake on this. You're talking about the documents that were obtained from Jen Abel's phone. Blake says the Jonesworks documents. How did you obtain the Jonesworks documents? So that was page 146. We're going straight down to 147. Okay, cool. We have to make sure that we don't skip, because it skips ahead pages sometimes, so I got to make sure it's the continuity's there. Blake says, can you be more specific? The lawyer says, did Leslie Sloan call you and tell you that she received information from Stephanie Jones about a smear campaign or something similar to that? Blake says she did not. The lawyer asks, did you learn from Leslie Sloan that there were text messages in Jen Abel's phone? Blake says no. Who did you learn that from? And Blake says Ashley and I don't know how to pronounce this girl's name, Avanon or Avignon. I'm not sure. We're just going to go with Ashley. So Friedman, or whatever attorney here, asks, who is that? Blake says, she's a friend of mine. And what did she tell you? Blake says, she said that a woman that she knows named Stephanie Jones was trying to get in touch with me. She gave me more details. Now, if I recall correctly, from information we've already seen, they went through Taylor Swift. I think Ashley went through Taylor Swift as well. So you guys can correct me if I'm wrong. I'm not 100% sure on that, but I feel pretty sure that she was involved. So, okay. Let me move this real quick. Okay, she said a woman she knows Jones trying to get in touch. When did she tell you that? Late August of 2024. And did she tell you that in writing or on the telephone? Blake says on the phone. And what else did she tell you? Blake says she told me that she works with a woman in I think she's an interior designer, and the woman's name is Stephanie Jones, and that she's a publicist, and that she has a phone which contains the most disturbing messages she's ever read in her 20 to 30 plus year career. That as a modern woman, she was sobbing at reading the messages. Okay, so Stephanie Jones apparently was sobbing reading these messages, and Blake must see them. I'm going to call bullshit on that, because Stephanie Jones, who's been working for 20 to 30 plus years, has certainly worked for some, how do I put this? Disgusting, probably, celebrities that she has to cover things up for. So I'm going to say this was not the most disturbing thing she's ever seen. I'm going to say that's an exaggeration. And this was more of a revenge motive than anything else. So Stephanie Jones stabbing the very recently former client in the back like this is insane. Hen's Homestead says, I pray Wayfarer sues her for breach of their contract with her. What a POS. I think they had counterclaims, but I think they got thrown out. I can't recall at the moment, but I will refresh my knowledge of all that soon, this coming weekend probably, just so I can tell you guys for sure. Because the Jones Abel case, a lot of it got kind of pushed to the back burner with the Wayfarer Lively case still going on. So Bruce says, this is why I never became a super famous Hollywood celebrity. I knew that was the only reason. You know? Okay. Sobbing, yeah. I know. Sobbing. I don't believe she was sobbing. I can't believe she was reading that phone and sobbing. This lady who brought the psychic to tell Jen Abel she was going to get pregnant with twins when she has fertility problems. Like, lady, clean your own house. You know what I mean? Okay. You says, how was Australia, Lauren? Well, I went to Australia months ago now. I miss it. But I've been going to Australia a couple times a year for the last several years. I've worked multiple jobs for a long time, and then I worked as hard as I could just to get money to travel. So it was good, but you know, it was too short. Hold on one sec, guys. All right. That she thought, okay, so we're talking, this is Blake talking about what Ashley relayed to her about Stephanie and the phone. Hey, Sarah, what's up? She says that she thought that I deserved to see what had been done to me. She said that she had reached out to my publicist, Leslie Sloan, to share the same and was brushed off. So if Leslie Sloan is brushing this off, there's a reason for that. It's because this is kind of bullshit. And she knew that this was stupid. But she said that she felt like I should see these messages and that they were on a phone that she had ownership of because it was a company phone. Company phone, yes, we know that. It was a Jones worked company phone. However, the phone number belonged to Jen Abel, and that's where we had some problems. When I first read this lawsuit, I was kind of really harsh on the publicists, all of them. And I was saying, why would you send personal messages on a company phone? However, I didn't know that a lot of people in the PR industry do that. Because a lot of us who work in, if you work in healthcare, you work in tech, whatever, like, you don't send personal messages on your work phone. They give you that for a purpose, and you don't use it outside of that purpose. But for PR people, apparently that's common. And so I've since, tried to back off from some of that judgment. I think that it's very bizarre what she did to her former employee and former client, like right after they left like this. This is just not a good look for a publicist. I can't imagine that I would ever hire Stephanie Jones, with all this. And Leslie Sloan, I'm not a fan of Leslie Sloan, God knows, right? But I think she did the right thing by brushing that off, because avoiding this huge mess was the right decision. And then Stephanie Jones enlisted somebody else to go to Blake. That's crazy, right? Okay. Did you speak with Stephanie Jones? Blake says, no, this was relayed to me through Ashley. And did you get a hold of those documents? Blake says eventually, yes. When was that? Fall of 2024. When you say fall, can you be more specific? She says, I don't know, but I would guess October. The lawyer asks, so you got this phone call in August, is that correct? Blake says, yes. And did you had no conversations with Stephanie Jones? Blake says, I did. Okay. When did you talk to Stephanie Jones for the first time? She says, likely a few days later, I would guess. Somewhere within a week. The lawyer asks, still in August? She says, I don't know if it was early September at this point. It could still be late August, early September, somewhere in there. Okay. Lawyer asks, and was it just the two of you on the phone? Blake says, I believe Ashley was on the phone as well. Okay. And what did Stephanie Jones tell you on that call? Blake says, she reflected more of what the sentiment that I already shared with you. She reiterated that. She said that she felt like, as a mother and as a woman, that I needed to see these messages. She warned me about the people involved and said that she would like to get me the documents. And I said it was really important to me to obtain them in a way that was legal, and to be that lawyers needed to coordinate that. So this is funny, because even when they tried to go through the legal process, they filed a sham lawsuit with the company Van Zandt. Van Zandt sued John Doe's so that they circumvent the rights of the Wayfarer parties and Jennifer Abel to fight the subpoena and say, no, you don't have any right to get the messages off my phone. So I don't necessarily know that that was legal. It doesn't sound like it's something that we're going to fight. But the thing is, Stephanie Jones here, what she's doing is a very bad look for a publicist. Because if you are a publicist for somebody, you're working a lot of times to suppress negative stories or negative news about them, right? And this is actually going out of her way to hurt the client by telling the person who hates them about all the nasty things that they've done or said. You know what I mean? So that's ridiculous. If I were, somebody who needed a publicist, I can't imagine I would ever hire her after seeing this. So, all right. Blake continues here. She says, she said she owned the phone, but agreed, and she said she would reach out to counsel. The lawyer asks, did Stephanie Jones tell you that Wayfarer was her client? Blake says, I don't know. I knew they at least had been her client. The lawyer asks, is it correct in saying that you knew that Stephanie Jones was the PR company working for Wayfarer? Blake says, I believe so. And you ultimately got a hold of those documents, correct? She says, I did. The lawyer asks, what is Van Zandt? I think they mean Van Zandt, obviously, but close enough. It's a corporate entity through which we run our household or personal employees and security. A broom closet, if you will. That wasn't Blake saying that was me. But the attorney asks, and who assisted in helping get those documents? She says, my lawyers. Anyone else? Just the people I mentioned. And what are those documents? You actually just got them and saw them and reviewed them. Is that correct? Blake says, yes. And you reviewed them in or around October. Is that right? Yes. And what did those documents tell you? It's a very broad question. Can you be more specific? Sure. Did anything in those documents actually state that something was done to create negative press about you? Blake says yes. The lawyer asks what was in those documents that said, and then it cuts off here, unfortunately. Like I said, we'll never see all of Blake Lively's deposition, unfortunately. At least I don't think so. So it cuts off there. But something interesting came up in this correction sheet, the errata sheet they put here, which means they had to change a spelling or grammar of something. What is Van Zandt? That was a correction because it said Van Zandt up there. So there was an interesting one here. It says, have you ever told anyone that you were in talks with Sony about obtaining the rights to this sequel? So that's interesting because why was she talking to them about obtaining the rights to the sequel? Kind of does sound like she was snaking it from under Justin. All right. But that's all we got here on this deposition. And then from our friends at Reddit, I have one more thing I wanted to look at. Pull that down. Give me 1 second here, guys. Okay. I'll try to zoom in on this, but I'm not sure if I can. Yeah, I don't think it's going to let me. What if I do this? Nope. That didn't help, did it? Okay. So hopefully you guys can read that. But these are some deposition pages from Katie Case, who formerly worked for TAG. And she was the one who knew a lot, apparently, about those websites that they were so interested in. And we're going to hear about some of that. Now, you guys, if you remember, it was said in some documents that came out in the Lively Wayfarer case that Dwayne "The Rock" Johnson was the one behind the website about Stephanie Jones, which is fucking hilarious. I didn't believe it at first. I thought they were insane. But no, apparently it is Dwayne "The Rock" Johnson. And we're going to hear some more about that here. Which is why I'm saying, like, Stephanie Jones' clients know that she's stabbing people in the back. This is not a good look. Okay. So Katie Case is answering some questions here. The attorney says Brian and Jed were working in collaboration with TAG on the Rebel Wilson account. Katie says, I didn't work on that account, so I'm not sure. The attorney says you worked on the copy that Melissa was requesting for that account, correct? Katie says that was a one-off request. So you did some work on that account, correct? Katie says, specifically, I assisted with this copy. The lawyer asks, and you knew what Jed and Brian were working together, asking for the copy that you were preparing for that account, correct? Melissa alerted me at that. And then let me see here. I think that might have skipped some pages. Let's see. Yeah, it skipped some pages, so we don't know what exactly she said there. Anyways, we're going to keep moving on here until we get to the Dwayne "The Rock" Johnson. Okay. Ms. Case, are you aware of various websites and social media accounts that are disparaging of Ms. Jones? She says, I am aware of websites about Ms. Jones. Did you create any of the websites that are disparaging of Ms. Jones? Katie Case says no. She says she doesn't know who did it. The lawyer says, how did you become aware of the websites that are disparaging of Ms. Jones? Okay. Katie says, I received a call from Melissa in early May. It was communicated to me that a website had been requested. All right. The creation of a website had been requested. And then they ask by whom? Okay. Katie says, Melissa represented to me that a potential new client had requested the formulation of a website. The lawyer asks, who was that new client? And Katie says, at the time, it was represented to me that it was Dwayne Johnson, who you all know as The Rock. So that's pretty crazy. All right. Katie says she represented to me that he had requested the creation of a website of this nature. All right. Did she tell you anything else about what Mr. Johnson had requested? Katie says not what he had requested specifically. They asked generally what he had requested. She says not necessarily what he had requested, but specific language was communicated. And I think her answers to these questions here are like, they're dodgy and they're bad, because like, this is obviously, you know, the answer to these questions. You're playing chicken. So I don't know. What was the specific language? She says that Stephanie holds clients hostage, that she leaks clients' secrets, and that she treats her employees poorly, amongst others. So those things sound like true things to me. So I don't know, like, could you really get a defamation award for that if you have actually leaked clients' secrets and treated her employees poorly? Like, these seem like well-established, maybe not facts, but at least opinions amongst people who have worked with her in the past. So that's crazy. Let's see. Ms. Nathan told you that Mr. Johnson had said the things that you just said to her? Katie says, no. Who did Ms. Nathan said that Stephanie holds clients hostage? Katie says, I don't know who might have said that. This language was communicated to me. Okay. Oh, shit. What's going on with my laptop here? Sorry, it was my screen just glitched. Let me know if everything's okay on y'all's end as far as the sound and video, but I think we're good. Hold on. Nope, that's not what I wanted to do. There we go. Okay. So that's kind of a dumb answer, I think. Did Ms. Nathan say that Stephanie holds clients hostage? Who did Ms. Nathan say said that Stephanie holds clients hostage? It's obviously Dwayne, right? That's the obvious answer to that question is Dwayne, and she's just being dodgy. Okay. All right. The lawyer asks, did you come to understand that the copy that you had drafted became a website about Miss Jones? Katie says, I was made aware of that, yes. Who made you aware of that? She says, Melissa. And what did Melissa tell you? She sent me the link. The link to which website? Katie says, it might have been the leaks. I don't remember which came first. So there was if you guys don't remember, these websites about Stephanie Jones, it was like Stephanie Jones Lies and Stephanie Jones Leaks, I think was the second one. So I'm assuming that's what she's referring to, that one came first. Those websites have since been removed, but at the start of these lawsuits, one of them was still up, and it was it was bizarre. All right. Okay, she sent it to her in a text message, and that text message sending Stephanie Jones Leaks you recognized as the copy that you had drafted, correct? Katie says that's correct. So Katie Case wrote the website. The lawyer says, did Mr. Johnson pay Tag to create this website? Katie says, I don't know. Did Mr. Johnson become a client of Tag? She says he did not. Okay. So to me, it kind of sounds like Katie did some freelancing work, but that's just me, you know? Do you know if Miss Nathan had any other conversation with Mr. Johnson other than the one you have already discussed? Katie says, I don't know. Did Miss Nathan report to you any other conversations with Mr. Johnson other than the one you have already discussed? She says, no. Do you recall anything else about that initial conversation with Mr. Johnson other than what you have already testified to? She says, it wasn't a conversation with Mr. Johnson. The lawyer asks, what was it with Mr. Johnson? Katie says, I never spoke to Mr. Johnson. Okay. The lawyer asks, I had understood that Miss Nathan had spoken with Mr. Johnson, and then Miss Nathan reported that to you. It's page 381. Yeah, we're good there. Okay. Katie says, I am not aware of whether or not Melissa spoke with Mr. Johnson. It was communicated to me that the site was at either his or someone affiliated with him's request. The lawyer asks, did she tell you if she ever spoke to him directly? Katie says, no. Did she tell you who she spoke to? No. Miss Case, you are now reviewing a document that has been marked as Case 35. It is a printout of the website, stephaniejonesleaks.com. Do you recognize this as the copy that you drafted? She says, I believe so, yes. Do you know how this went from the copy that you drafted to becoming a website? I do not. Did Melissa communicate anything to you about how this became a website after you provided her with the copy? And then that's where it cuts off on this post. So, but thanks again to our friends at Reddit for recapping that and putting the screenshots in. That helps me out a lot. Okay. Let me see. So there was one more thing I hadn't gone over yet that I wanted to look at, and it was this back and forth between Blake Lively and Jed Wallace's attorneys about whether or not they can depose Blake Lively related to her trying to get 47.1 damages against Jed Wallace. So Blake's attorneys were very threatening. Apparently, they told them they were going to charge Blake out the ass and make Jed pay for it if they did this. So we'll take a look at it really quick. It's a short document. Hold on. If I can, there we go. Nope. I'm going to move off to the side more. No. Okay, there we go. So this is the reply in support of the motion for the order to depose Blake Lively. It says, relying on first impression authority, which Lively brought to the court's attention on June 12th, she remarkably argues that the Wallace parties must prove the malice element of Lively's privilege to avoid nearly $1 million in fee shifting under an extraterritorial California procedural statute. Remember, this is taking place in Texas. So, in a case dismissed solely on jurisdictional grounds where no merits determination has been made, all while Lively simultaneously insists the Wallace parties may not develop that evidence from the primary source, Lively herself. And Blake Lively's case against Jed Wallace was dismissed because it was not in the jurisdiction of the New York court. Jed Wallace's case against Blake Lively was dismissed also for, issues of jurisdiction. So they kind of had the same things cancel their cases out, but Blake Lively is asking for 47.1 damages, which is, of course, based on retaliation for reports of sexual harassment against Jed, who has never met or seen Blake in person. So it's really bizarre. All right. Lively's argument that the Wallace parties seek to reopen the record and take a second deposition is at best misleading and frankly demonstrably false. There was no first deposition of her in this case because Lively actively prevented it. The Wallace parties only deposed Lively for 1 hour on primarily personal jurisdiction issues, but not on her malice, which was not an issue in litigation she brought in the Southern District of New York against multiple defendants, including the Wallace parties. But they expressly reserved their right to obtain further deposition testimony from Lively in the event they were not subsequently dismissed, which they were. Right. Okay. And then footnote 3, which they note there, says, see Exhibit B, Lively's deposition transcript. So this is related to her deposition in the Wayfarer case where the Wallace parties were still sort of involved because she was going to amend against them. Okay. Babcock, the attorney, says, we have been permitted to ask questions for only an hour, and we object to that, and we will move, if appropriate, for an order of the court to reconvene this deposition, adding that if we're not dismissed, just wait, we might ask for more time. Okay. Far from waiving their rights, the Wallace parties in this case began an immediate effort to depose Lively after her counsel's June 12th supplemental argument. The only delay in scheduling this deposition, which was only 4 weeks in any event, was while counsel discussed settlement. Lively cites no authority recognizing the extreme results she seeks under the procedural posture before this court. Okay. Lively's waiver argument is without legal or factual support, and this is where I'm going to skim around a little bit, guys. Waiver requires the intentional relinquishment or abandonment of a known right. Okay. The Wallace parties have diligently pursued Lively's deposition since she argued after briefing concluded on her fees motion that the opinion in her SDNY case holds under California law. A defamation plaintiff bears the burden to establish malice at every stage of the litigation and must ultimately prove malice at trial to avoid application of the Section 47.1 fee shifting right. Even sufficiently alleging malice is insufficient to avoid fee shifting if the plaintiff does not ultimately prevail at trial. From that point, the Wallace parties engaged with Lively's counsel through phone calls and email to schedule her deposition. Notably, these developments unfolded at a time when the parties were engaging in ongoing, but ultimately unsuccessful, settlement discussions. After failing to reach agreement regarding Lively's deposition, the Wallace parties served their notice on July 13th. So that was like 6 weeks ago-ish, around that time. Their prompt effort to obtain discovery of Lively's malice, information unique to her, that she demands based on post-briefing arguments she filed, falls short of evidencing an intentional relinquishment of any known right. Okay. The Wallace parties repeat that they dispute Judge Lyman's ruling is controlling here, as it arose from a materially different procedural posture. Unlike this case, dismissed on jurisdictional grounds without prejudice and without reaching the merits, the Wayfarer ruling, which did not include the Wallace parties, involved claims dismissed with prejudice under Rule 12b-6 based on California's substantive law that the parties agreed applied. Okay. But if the court considers Lively's burden-shifting argument based on that supplemental authority, then the Wallace parties are entitled to the narrowly tailored deposition they seek under Rule 54. Lively's cited cases do not support her waiver argument. And that's where I'm going to skim over some of this stuff, guys, because that's obviously not my area of expertise. So I don't think I should be evaluating case law. All right. Lively's argument that the Wallace parties deposed her on the exact issues relevant to her fee motion in the New York litigation, not this case, is demonstrably untrue. That deposition occurred after Wallace and Street were dismissed the first time from that litigation for lack of personal jurisdiction, but while Lively had leave to amend her complaint, which she did just before midnight the night before. This is where she put those Instagram posts where she was saying like blue jean lady or whatever, New York something. And she tried to say that that was something that should have made Wallace aware that the jurisdiction was in New York. It was kind of crazy. I remember that. It did not work, by the way. Right. Hold on. The Wallace parties were allocated 1 hour to explore primarily whether there was a personal jurisdiction over them in New York. So they had 1 hour to ask questions that were not related to the kinds of questions they would want to ask in the deposition here if they are granted that deposition. So these questions were related to jurisdiction in her case against them. Right. Following the deposition, the court again ruled there was not, based in parts on excerpts from the 1 hour deposition, dismissing Wallace and Street the second time. Okay. At the time of Lively's July 2025 New York deposition, there was no pending Section 47.1 motion in that or this litigation, nor did the substantive claims in New York, where Wallace and Street were defendants, involve her malice. So they couldn't have asked her these questions at that time because they weren't relevant, is kind of what they're saying. Like, they need to ask these questions now because she has raised this issue of 47.1 damages. Okay. The only malice issue in New York concerned the defendants, not Lively's. So she was not already deposed on these exact issues. We appreciate that Lively admits she is not claiming that Wallace sexually harassed her. Well, how noble of her. Nor could she, but whether a jury might find that she did falsely accuse him of that and participating in a retaliatory smear campaign, either knowing those allegations were false or in reckless disregard of the truth, malice, when she published her CRD and draft complaints to the New York Times, goes to the merits, which were not reached by this court nor explored in the 1 hour deposition. Okay. Indeed, Lively's counsel demanded strict compliance with the 1 hour limit, interrupting the Wallace party's questioning and abruptly ending the deposition as counsel began questioning Lively about her Rule 202 petition. Right. The Wallace party's notice of deposition was proper and not frivolous. Contrary to Lively's assertion, the Wallace parties do not concede that leave of court was required before serving a notice of deposition, nor do they concede their notice never had any legal basis whatsoever. Lively cites no authority, nor are the Wallace parties aware of any, for the proposition that leave of court must be granted before service of a notice of deposition under the procedural posture of this case. Nevertheless, Lively simply decided that issue in her favor when she failed to appear for her deposition without seeking a protective order, as the rules require. The Wallace parties accordingly seek an order from this court, as Lively's counsel has made clear she will not appear otherwise. Okay. They write here, Lively is not entitled to any fees, much less fees on fees, for responding to the Wallace party's motion. So fees on fees is like the fees you have to pay for the attorneys writing the fee motions and that kind of thing. Lively is not entitled to any fees, including fees on fees, for litigating either her own motion or this motion. The Wallace party's motion is both procedurally proper and substantially justified given this case's procedural posture and Lively's novel burden-shifting argument. Lively's request for fees on fees should be denied, and the court should award the Wallace parties their attorney's fees under Rule 37D. Okay, so their conclusion is the court should deny Lively's fee request and grant the Wallace parties their fees, and in the meantime, order Lively's deposition to allow the Wallace parties to develop the evidentiary record on the issue of malice. So they're waiting for the judge to rule on this now to see whether or not they can have her deposed on these specific issues, which is not something that they could have asked during her previous deposition. So, all right. Well, I think this was a short one, but I think that's it for me tonight, guys, on the Lively cases. I will be back to looking at this stuff in real time, so I'll be keeping up better in the future, but I needed a little break from these. I think between seeing what happened with Perez and seeing what's happening online in the Clancy case, I just started feeling terrible about how much hate there was in the world and how there was no limit to like people's cruelty. It just got awful. And so when I thought about this and everything that I've done and the kind of commentary that I've done in the past, which if you guys have been listening to me for a while, you already know that I have been trying to change things. I don't know. I just felt like I don't want to contribute to all that hatred. So while I want to be able to fairly criticize these things and these people, I don't want to be mean just to be mean. You know what I mean? So I had to take a little break from all this. That didn't stop weird Blake Lively stands from making strange conspiracies about me, of course, but you know, they're never going to go away. I've come to terms with that. So, all right, guys. I appreciate you being here watching this. Don't forget to hit the like button for me. It helps me out a lot. I will be back at midnight with Omar to discuss the Clancy case if you guys want to watch that. And I will see you soon. All right. Thanks, everyone. Bye.